solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
Okay.
Right out of the gate, we're not easing into this. We're diving straight into suspicion when a judge opens with confidence that someone has been drinking that tells you one thing. This isn't their first rodeo. The court is already looking at patterns, not just one incident. And here's the question for you. Do you think this is intuition speaking or evidence already stacking up behind the scenes?
Sure. On February 5th, Ms. Greathouse was referred to house arrest services to obtain her SoberLink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greathouse was positive for alcohol at 7:27 p.m. with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring it on.
Now this is critical. A 0.0019% reading. May sound small, but context is everything. When you're on a sobriety monitoring device like SilverLink, the expectation is zero. Not almost zero. Not close enough. Zero. And notice the pattern building: multiple dates, multiple readings. This isn't about one slip, it's about consistency in
Name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to let her conclude, and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the SoberLink, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol 7:27 p.m. at 0.019%.
That 20% cutoff is procedural. It determines whether the device forces a retest, but don't confuse procedural thresholds with innocence. Even readings under that line can still show alcohol presence, so the defense might argue under the cutoff. But the prosecution hears still positive. See the tension building?
For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Ms. Greathouse was positive at a 0.029%. She called house arrest services claiming this was due to brushing her teeth. House arrest services did inform her to continue to blow as required. So at 11:17, she was and this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required. Continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff. Continued to be positive that day at 11:22 p.m. at 0.025% and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%, and at 11 p.m. she did fail to blow. An hour and 55 minutes later, at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear, but the one excuse that Ms. Greathouse used about brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them.
This is a strong assertion. The probation side is no longer talking about toothpaste or mouthwash. They're framing this as direct alcohol consumption. And that's a big leap, because now the narrative shifts from device glitch to active drinking. The stakes just escalated dramatically.
That indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Ms. Greathouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay. Do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify. Reliable this device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not.
Christopher Cruz.
My questions are Mr. Hunt.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
And there it is, the phrase that changes everything. Consistent with drinking, notice the expert's evolution, knee-jerk reaction, possible malfunction after. Reviewing the data. Pattern of consumption, that's powerful testimony. But let me ask you, does consistent with equal proof beyond doubt, or is there still room for reasonable uncertainty?
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hunt, when my client called Silverland to complain about the device, did she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Ms. Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take multiple, to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other notes?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Miss Greyhouse.
Isn't it true that these devices sometimes fail before reading 1,500 bits?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
You don't.
no, I do not. No.
There are nothing further to say.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
Elimination rates. That's science entering the courtroom. Alcohol metabolizes at predictable speeds, so when readings rise and fall in a certain pattern, it can indicate new consumption rather than residue. That's why this email hits hard. It's not just numbers, it's timing and timing. Tells stories. The big question now, will the judge see a malfunction or a mathematical smoking gun?
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, this is just totally across the cap.
Wait a minute. I want to interject.
I wasn't done.
Yeah, let her finish first. Go ahead. We want to ask a question.
Yeah, I had a follow-up question to that, but I know Mr. Longton chimed in. Mr. Hunt, and it actually alluded to what Mr. Longton was.